Mr. Chairman. Sorry, I was being very good about mute. But thank you, Mr. Chairman, for having this hearing. And thank you, Ms. Clarke, for your testimony. It's very important for our deliberations as we bring the next John Lewis Voting Rights Act forward. The rise in voter suppression laws across the country have revealed critical gaps in the Voting Rights Act and its ability to protect the right to vote and to allow affected parties to obtain timely relief under the claims that they pursue. And we have certainly seen this in my home state of North Carolina. I want to bring up the Thornburg versus Jingles case, which did come from North Carolina, where the Supreme Court outlined a non-exhaustive list of factors that a court should consider in vote dilution Section 2 cases. In any legislative response to the Brnovich decision, do you think it's important for Congress to explicitly clarify that Section 2B continues to apply to vote dilution claims and that courts must apply the Jingles decision to those claims? And if so, please tell me why.
Thank you for that question, Congressman. So the Justice Department thinks that it would be valuable for Congress to look carefully at the Brnovich ruling and the factors set forth in the opinion to see whether there's a divergence between the factors that this body had intended courts and litigants to consider in Section 2 cases. And clarity, I think, can be very helpful for the Justice Department and for other litigants that pursue Section 2 cases going forward. But that said, the Brnovich ruling leaves Section 2 intact, and it remains an important tool that we are using to safeguard voting rights across the country.
Thank you very much for that answer. We've also heard testimony this Congress that the lower court's over-reliance on the so-called Purcell principle has made it inordinately difficult for Section 2 plaintiffs to obtain equitable relief in cases involving late-breaking changes to voting procedures. Should Congress consider amending the VRA to address Purcell, and if so, how?
Well, again, Congressman, Congress bears broad enforcement powers under the Section 2 of the 15th Amendment, Section 5 of the 14th Amendment, the Elections Clause, which gives Congress the power to speak to the time, place, and manner by which voters can access the ballot in federal elections. So all three of these provisions truly give Congress the power to provide clarity about how it intends Section 2 to be used. So my answer to your question is yes, this is an area that we would encourage Congress to look at and explore further.
And as a follow-up to that question, do you think it is particularly important for us to look at this principle in light of the upcoming redistricting that we will be doing based on the census results?
Yes, Congresswoman. The Supreme Court has urged Congress to look at current conditions. And we know over the course of the past decade, course of the past few decades, that redistricting is a moment where we see discrimination rear its ugly head. We have seen racially gerrymandered plans. We have seen efforts to hack minority voters into districts in ways that harm their ability to access the ballot. We've seen cracking of minority voters across districts. And so there is a track record here. And I think that the upcoming redistricting cycle underscores the urgency of Congress resolving this issue now, of speaking to the Shelby Court ruling now and ensuring that we have the full protections of the act back in place before the upcoming decennial redistricting cycle gets fully underway.
Thank you very much. And Mr. Chairman, I yield back.